Hi, I'm so excited to be here. I'm sorry about my voice. It's a little squeaky this morning. If you haven't already, you will hear my accent. Just to get that out of the way, I am Romanian. I was born and raised in Romania. Um, that's for another day to tell you my story. But today I am so excited to be here because I am truly passionate about talking about estate planning. And I'm excited to talk to OU employees today about maybe some of the most important documents that you will or should sign. So we're going to focus on medical decisions today, on the documents related to medical decisions. But first, let's start with some estate planning basics. And what is estate planning? I am almost certain that most of us here today think about estate planning as what happens after death. Um, and sometimes people say, well, I don't care what happens anyway. I don't have that much, or I'll be dead. What do I care? But in reality, estate planning, a big part of it, maybe the more important part of it, has to do with incapacity. Incapacity means, and we have the definition there on the slide. And by the way, I know the slides are a little dense and you're not supposed to do that, but I chose to do that because I want you guys to have this information available, to go back and just read that, process and focus and take notes as much as you can today during the meeting, but no, you can go back and read the entire description of some of these terms and topics. Incapacity, and I have a legal definition there, is a lack of physical, mental, cognitive ability that results in a person's inability to manage their own affairs. So what does that mean when a person is incapacitated, and why would a person be incapacitated? Let's say one is in a car accident and is taken to the hospital unconscious. What happens then? Who gets to make medical decision? Who gets to pick up the kids from school or pay bills and things like that? Talk to the insurance and see what's covered, what's not covered. And that's what we're going to talk about today. Here are the documents that are usually included in an estate plan. Power of attorneys, we have financial and healthcare. We have an advance directive. We have a HIPAA release, a DNR, a last will and testament. And then finally, we have a few documents that avoid probate. And that's again for another day. We're not going to talk about that today. We're going to focus on the medical stuff, but just know that there are other documents that you should consider or you should research and looking into. So the estate planning basics, the medical documents we're covered today are the healthcare power of attorney, again, the advance directive, HIPAA, and the DNR. Before I move on with the medical documents, I just wanted to bring it up, just as Kaylee said, I do teach classes at the Well. This is the flyer. You have the flyer on your screen. I hope if you live in Norman, you've been to the Well. That's where the farmers market moved. It's an amazing place. They have lots of classes. They have cooking classes and education and fitness. So I am there twice a month, once in the morning and then once in the afternoon. Please consider joining a class if you want to learn more about today's topics and about the other documents that we're not going to address today, such as financial power of attorney. We talk a lot about probate, what it means. We'll talk about trust, wills, and such. But just know there is a QR code there you can sign up, and you can always email me or you'll get these slides emailed to you. Let's go to the actual documents now, to the medical documents. There's so much to talk about. I could talk about at the Well last week. The class is supposed to be an hour and we were there 2.5 hours. There's just so much to talk about, and I am going to respect your time today. And I'll try to be done in like 45 minutes and then give you the opportunity to ask any questions. We're going to start with a healthcare power of attorney. Again, we're not going to address the financial, we'll stick to medical. And this is where the dense slide comes into play. And I highlighted or some of the words that I want you to remember or that are important. I have taken this language exactly out of the statute. It says right there, Title 63, the public health and safety. A person with capacity may execute a power of attorney for healthcare, which may authorize the agent to make decisions if the principal is unable. So there are some things here that we need to talk about to bring it down to how does this apply to me? What does this even mean? First of all, you can execute a power of attorney. We all kind of know what a power of attorney is a document that says I appoint my spouse, I appoint my sister, my best friend to make decisions for me if I'm unable to. If my sister or my friend cannot do it, then I appoint this other person and so on. So what's the first paragraph there says you have to have capacity. When is a good time to get a power of attorney? Right now, that you do have capacity, that you are thinking about this. The fact that you're here today tells me that you are thinking about this. Please don't postpone because it can be too late to sign any of these documents. Let me give you an example. A few years back, I had this sweet old lady call my office. She said, my husband is in the VA hospital. They tell me I need a power of attorney in order to make medical decisions and to arrange his VA benefits. And I said, okay, well, how is he doing? And she said, well, he's not doing well. He's on hospice. He's passing. It's too late. A person has to be able to sign and has to understand what's going on. So when should you get the power of attorney? Now is the time to get it. Um, Authorizes the agent. That's when you appoint someone to make healthcare decisions. And then this accepts the advance directive. We're going to talk about the advance directive in a minute. I know people get confused between when is the healthcare power of attorney working, when is and what is the advance directive. We're going to spend a lot of time on the advance directive in a minute. The power has to be done in writing, signed by the principal, right? You have to have the document. You can tell someone, hey, best friend, you can make medical decisions for me if something happens, but when you go to the hospital, the doctors are going to want to see the document. So make sure that if you do have documents, people who are listed within know that you have them and know how to access them. People ask me sometimes, I have to tell my mom that she's my healthcare power of attorney. You don't have to, but ideally you do, because we'll talk about that in a minute. They have to know your wishes, but also they have to have the opportunity to say, oh my God, don't list me because I'm not gonna do it. So don't take this lightly. Don't just list someone there, but you can, you know, if it's just a weird situation or people don't like to talk about it, you can list someone. It's better than not listing anyone. And then they'll have the decision, the option at that time to do it or not do it. But that's why we have an alternate. That way, if your first person says, no, this is just too much for me, it can go down to the next and you can have two or three more others. And let's otherwise specify the power of attorney. Okay, the authority begins effective only if the person lacks capacity. This is everyone's main concern, a question I get asked all the time. That's why I referenced it in here. What does that mean? If I have a power of attorney and my spouse has it, he is or she is my power of attorney, does that mean they can just start making decisions now and go and do things? Most power of attorneys stay within the document when that document is effective. So the financial power of attorney is a little different. You have the option to define exactly what incapacity is, which usually is to licensed physicians. But the healthcare power of attorney is usually effective if the person is unable to. So let's use an example. Um, you have power of attorney over mom. You are mom's medical power of attorney. You heard that she had a stroke. She's in the hospital. You walk in with a document, or ideally, mom already had given that document to your healthcare providers, and they will allow you to make decisions, sign consents, and things like that, but only if mom is unable to. So as long as mom is able to communicate, and communicate, as you know, is not just talking. If she blinks twice for yes or no or something like that, or squeezes your hand, that is communicating, and the power of attorney does not apply until that person is unable to make decisions. So I hope that makes sense there because it's a big question. Again, the financial document is a little bit different, but this says only if the person lacks capacity. Now, who determines if the person lacks capacity, right? Because if the person is in a coma, then it's clear the person lacks capacity. But sometimes people have moments of lucidity, or they may make sense now, but 5 minutes later they won't. Here says, unless otherwise specified, determination that an individual lacks capacity shall be made by the attending physician. What does that mean? Again, mom is in the hospital. She is being seen by a physician. That physician will make that decision. Okay, mom cannot make these decisions. I'm not confident that mom understands what's going on. Then they will allow the power of attorney, whomever is listed on the document, to make decisions. unless otherwise specified. If you want to make that incapacity determination by someone else, you can in the document. So for example, if you like Dr. Smith very much and he knows you and you trust him better to make that decision, you can specify that in the document. It can get a little more complicated then because they have to reach Dr. Smith and so on. Most power of attorneys, especially the healthcare ones, the physician, the attending physician, or you can sometimes, if you're worried that someone may misuse it, you can have two attending physicians, which oftentimes, if you're in a car accident or if you have a mental condition like Alzheimer's or dementia or something, you're being seen by at least two physicians, so that should take care of things. An agent shall make healthcare decisions in accordance to the principal's individual instructions, if any, or other wishes to the extent known to the agent. So it is very important. I cannot stress this enough. This goes back to the question, should I tell this person that I nominated them as my healthcare agent? You should, because of this, because the power of attorney has to follow your instructions. Um, or any wishes known to them. So if it's someone close, like your spouse, they probably know your wishes. If it's someone that is not very close, someone that you don't see very often, then maybe you may want to have something in writing. Don't rely on all the documents. Don't rely on people remembering your stuff, okay? Because it's hard enough for us to remember our things, our codes and passcodes and passwords and doctors' names and information. Please have it written somewhere and tell that person, hey, best friend, just so you know, I have a list somewhere. This is how you access it. This takes me, and I think there is a slide on that. If you do have people have important documents in a safe or a safe deposit box, well, who knows about your safe deposit box and who can access it? Or if you have a safe, who knows how to get into the safe? If there's a medical emergency and someone needs that document, how are they going to get in the safe? So plan it, and then in the safe with the documents, have a list. And we'll talk about that in a minute. Have a list with your doctors, allergies, preferences, your wishes. Sometimes people, for religious or cultural beliefs, they may not want this and that done. Sometimes people feel strongly about a certain hospital network. So just make sure your healthcare agent knows your wishes so they can apply them. Otherwise, if they don't know your wishes, if you list your best friend and she has no idea, or this is a stressful time, I mean, it's hard enough for us to make medical decisions for ourselves, honestly. And then you're just dropping that on to your best friend. They're just going to have to do what's in your best interest. And of course, many times the doctors make that decision. They can communicate with her because most of us don't have medical knowledge. So but that's how they determine which way to go, what's in your best interest based on what the doctors recommend, I imagine. The power of attorney for healthcare should be signed in front of a notary and two witnesses. It has to be a written document, signed in front by yourself, two witnesses and a notary. Sometimes people, before, I think the law changed last year or 2 years ago, you may remember there was a big scandal how the healthcare power of attorneys were no longer valid. Before, I think they did not require the notary. I think it was just two witnesses. Some of those documents may still work, but I would recommend if you have older documents, just to make sure that they are still valid. And one way, when people call me and they say, hey, my power of attorney is 10 years old, or my financial this and that is this old, do you think it's still good? I really don't know. A lot of entities have their own rules in addition to the law that we're reading together. They have a lot of rules. Bank of America won't accept a power of attorney, a financial one that's older than, I don't know, 5 years, even though the document does not expire. So what I recommend, if you have documents, you're not sure if they're still good, I would recommend that you start giving them to the entities that will need them if something happens to you. So if you have a financial power of attorney, take it to the bank and say, hey, bank, if I become incapacitated, will you accept this document? And they're going to say, okay, we'll send it to legal and we'll get back with you. And that's a good way for you to know, okay, this will work or this won't work. The same with the medical ones, just give them to your healthcare providers. It's just good practice. So that way, again, if there is a car accident and you're taking to the hospital, nobody has to rush home to pick them up. They already have them on file. And ideally, you have contact information for those people you have listed within to make for a smooth transition. I know some older clients of mine sometimes have copies of these medical documents we're going to talk about today in their car. Again, the documents don't have personal information. They just have your name, someone, your agent's names, and then it's just signed. So even if someone breaks in, they shouldn't be able to do much with these documents. Okay, so let's talk about some to-dos. I already addressed some of those. To-dos are a big part of my class at the Well, just because people like to know in practice, how does that work? Okay, like what are some of the things we can do today, even if you don't have a document? So the first one, think about, talk to, designate in writing a person to communicate. We kind of talked about this. You need a medical power of attorney. Every person over the age of 18 needs a medical power of attorney. Because we'll talk about it in a minute, what happens if you don't have one and you are in a car accident. So how do you get a medical power of attorney? Ideally, you work with an estate planning attorney. And you notice I did not say just an attorney, I put down an estate planning attorney. Hopefully, if you decide to hire an attorney, someone who specializes in this area, because estate planning is so much more than the actual document, kind of like we talked about now. There's a lot of things that go with it that maybe an attorney who does not do estate planning on a regular basis may not know. But let's say you're not ready to sit down with an attorney just yet. For now, you're thinking about it, you're talking to the people, you're starting to make lists. You can also find a form online from an Oklahoma organization. So I have some examples there, and I have done this before I started this slide, so I know it works. For example, I put down Google Oklahoma Healthcare Power of Attorney. Make sure it's Oklahoma, right? Because other states may have different laws. And Google Oklahoma Power of Attorney. And then it's going to be a bunch of entries there, some law firms, some PDF filler, and some this and that. You don't want to pick those, of course. You want to pick a .gov source. And there are all kinds of .gov source, that's somewhat reliable, or a hospital network like Norman Regional or Integris. If you have VA benefits, the VA, I know absolutely they have their own form, and you can get that for free from them, or ask your healthcare provider for a form. So let's say you have a surgery coming up and they ask you to have a healthcare power of attorney, just in case we need to talk to someone while you're under anesthesia. No, I actually don't. Do you guys have a form I can use? Because I have another example on when to use this. During COVID, someone called and they needed one. And I said, sorry, it's too late. We cannot get into the hospital. You cannot get two witnesses and a notary there. But he said, oh, no, the hospital found one. They gave me one. So that's your last resource. But at least consider talking to an attorney and then Google some things, use a reputable form. Talk to your trusted people about your wishes, leave written instructions. We talked about this already. Don't rely on people remembering things. Your medications, I mean, you may have a hard time keeping track, okay? Your allergies, your preferences, leave written instructions and make sure they can access them easily. Make lists with healthcare providers' information, allergies, medication, insurance policies. That's a big one. Now, if you are in a car accident and they take you to your local doctor already has all that information, hopefully. But if you're on vacation in Missouri and you're in a car accident and they take you to that doctor over there, they're not going to have any of your insurance information. So we want to make sure that everything is of record and they can bill the right people so you don't get this ridiculous bill. Keep them safe, but easily accessible place. Again, hey, I have a safe. If you don't want to tell people my code is this or the key is there, you can just say the code is written down and it's in this book or in the drawer or something like that. Provide copies to your healthcare providers. We talked about this. That's the best way to do it. There you have a patient portal probably, or when you go in, we'll talk about the advanced directive in a minute. They ask you all the time, do you have an advanced directive? Yes, I do. Here it is. Can you save a copy in your file? So that was to-dos. Let's talk about revocation. People ask me, when is the power of attorney revoked? Very briefly here, we can revoke it in signing, in writing, saying, I don't want this to be good anymore. Divorce can also revoke automatically a power of attorney, so be mindful of that unless otherwise specified. So if you still want your former spouse to make decisions, you have to specify somewhere. And if you get a new one, usually that revokes the previous one. Okay, now let's talk about what happens if you don't have a power of attorney. So let's go back to the example with mom. Mom is in a car accident. She's taken to the hospital. The three kids go there. The spouse is there. Mom's mom is there. Best friend is there. They're all there, and they all start saying things, what should happen, what the doctor should do. And the doctor's gonna ask, is there a power of attorney? And they're gonna say, well, no, we don't think so. Mom has been talking about it, but I don't think there is one. What happens then? An adult guardianship proceeding will have to be filed. What does that mean? Someone will have to go in front of a judge and apply for guardianship. Who is this someone? It's usually, and you have a list of priorities here, usually someone close to the person. Um, and it has here anyone nominated if there is a nomination somewhere, a current guardian, if there is someone nominated in a will, the spouse has priority over kids, and so on. You don't want to go there. So an adult guardianship proceeding, as you can imagine, is going to be a few $1,000s. You have no control over who applies. So maybe you have a terrible spouse, or maybe one of the kids, and I see this often, may want to apply for guardianship for the wrong reasons, either because they want to control where mom or what happens to mom, or because of money, or because whatever reason. So an adult guardianship proceeding again means you go in front of a judge, you give notice to everyone, it's the whole process. And then the judge is gonna look at these 3, 5 people who have applied, and they have to pick someone. And that's really hard to do because the judge doesn't know you, doesn't know these people. So unless they have felonies or something going on, they are to be considered based on this priority list. And then the judge is gonna appoint one or sometimes 2, 3 co-guardians, and then it's just gonna be a hassle. And again, these people who the judge may appoint may not be the people you want to be the ones making decisions. So if you are in a situation when you think, oh my God, I wouldn't want this person to be able to make decisions for me, please get something in writing. And getting an estate planning in place, it's often less expensive than having to deal with one court proceeding, like a guardianship of a probate or something. So, the alternative, mom is in the hospital, she's in a car accident, she doesn't have a power of attorney. Who gets to make decisions? Because the doctors are not going to allow anyone to sign, make consent, or decide on the course of treatment. Now, of course, the doctors, the healthcare personnel will give you all the care you need at that time, but sometimes you get to a point where we can go this way or this way. So who's gonna be the one making that decision? The doctor is gonna say, bring me a guardianship documents, and then we'll follow your decision. So it's expensive, it's stressful, trust me. The last thing you wanna do when someone is in the hospital is to try to find a lawyer and go in front of a judge and come up with medical records that you actually don't have access to because you don't have documents in writing. So it can be messy. Please consider getting a power of attorney. This is going back to our estate planning basics. Now we're gonna talk about the advanced directive, the document that they ask you all the time. Do you have one? I know everyone here, even the young ones, they probably get asked if they have one. Advanced healthcare directive, or sometimes people call it a living will, is part of the document. Now, we have a little definition there. It's a legal document that allows you to write down your wishes for healthcare treatment during the end stage of your life. So people often ask me, what's the difference between the healthcare power of attorney and the advanced directive? The advanced directive is end of life decisions. We're going to talk about it in a minute. We're going to look at it in a minute. That's the difference. So if you go in a hospital because you have hip surgery scheduled, you're not dying. So then the healthcare power of attorney gets to make decisions and help you with that process. But if you have terminal cancer, you have a stroke or something like that, when it's a terminal condition, then the advanced healthcare directive may apply. Sometimes people ask me, what about is like unclear. If you're in a car accident, you could be not dying, but you could be dying, like brain dead or something like that. So what happens if the healthcare power of attorney and the advance directive people don't agree on a course of action? That's why I strongly recommend that you have the same people. So the people who are your healthcare power of attorney should be the same person who is the person nominated in your advanced healthcare directive to make decisions for you. So that way we don't have that conflict. The Advanced Healthcare Directive goes into effect if two licensed physicians say that you are going to die within 6 months. It's listed in the document, and it covers three conditions: terminal condition, persistently unconscious, and end stage condition. Like, what does that even mean? I'm a lawyer. You guys do whatever you guys do at OU. Some of you may be in the medical field. Like, I don't know what a terminal condition is. Persistently unconscious, I could guess, I guess. End stage condition, I think about cancer. Is that what that is? I don't know. So the way I handle the advanced healthcare directive with my clients, I just give them that to take home and then advise them to seek help from a medical professional to help you with this document. But when I was Googling Oklahoma Advanced Healthcare Directive, and I'm going to click this link here, you're going to have it in your slide. OU Health has a very, very good resource on the advanced healthcare planning. So it talks about the advanced healthcare directive. Do I need one? What is it? How do I, and then it has this, it even has quiz, but you can download this form here, and I'm not going to click on it, but I printed it out, and it has very, very good information. Like it has, it talks about what's end stage condition. It talks about what's hospice care. You can have, how you should have the conversation with someone. Because, and there's something that I don't think I talked about before. The best way to have these conversations again is now that you are healthy. Because let me tell you, when someone is in the hospital and they are dying or they are terribly sick, the last thing you're going to want to know is, hey, do you want to be an organ donor or not? So talk about it now. Well, you're healthy, they're healthy, and again, this form is free. We're gonna talk about that. It's a statutory form, meaning that the law wants you so badly to have one that they put it in the statute word by word, and you can get it out of many, many resources. You can download it, print it out. But this resource here on OU Health, it's really good. So it talks about looking at one, and it says initial here if you do not want life-sustaining treatment. But somewhere in here, it talks about what life-sustaining treatment is. Is that antibiotics? Is that oxygen? I don't know. So do your research. You have this resource available. And also, again, when you go to the doctor, talk to them about some of your questions and say, is this condition of mine? Hold on, let me see if I can figure this out. I don't know if I know how to get back. Oh, there we go. So that's the OU Health link. You have it there. And I also did a QR code for you guys, make it convenient to go to that website because it has such great resources for you. And I also added another link, the Oklahoma Bar Association one. It has, again, very good, it answers some of the questions that you may have about the Advanced Healthcare Directive, who can sign it, uh, can I revoke it? How do you revoke it? And you can get a free form from here too. I'm not sure. Yeah, everybody can see it. Okay, good. So you can even get a free form from here. There are many other websites such as Norman Regional, Integris. If you Google Oklahoma, again, Oklahoma, and I think I may have it here. I don't know. Oklahoma Advanced Healthcare Directive. And you find, again, a good website, an OU, a .gov, an OBA, or Norman Regional Integris, you'll have very good resources there. So there'll be no reason, this is what I tell my people at the well, there's no reason why all of you should not have an advanced healthcare directive after today's presentation, really, because there are so many ways you can get one. You download it. It has to be signing just in front of just two witnesses. I joke about it at the well, just print 5 and take it to a birthday party or Thanksgiving dinner or something like that. might not be a fun topic, but it might be nice to get it out of the way, or take it to work, to church or somewhere. It just needs two witnesses. This is an example. This is the first portion of the Advanced Healthcare Directive, a terminal condition. And it says if I have a terminal condition that is incurably irreversible, that even with the administration of life-sustaining treatment will result, in the opinion of two licensed physicians, in death within 6 months, again, end of life. It does not apply if you go in for a hip surgery. What do you want to happen? I'm not going to go over that. It's medical stuff. Please use your resources and figure out which option you think you would want to apply to you. The form also allows you to apply to designate a healthcare proxy, that person who would actually sign the documents, make the decisions, talk to the physicians. Again, if you have a healthcare power of attorney, ideally it's the same one. So that way there will be no conflict there. And then it also covers if you want to be an organ donor, and it goes into detail with a little creepy, maybe like body parts and things like that if you don't want your whole body. It does not have to be notarized. I talked about that. So that should make it easier for you to get one. You guys are at work now, most of you, so you can go ahead and print it out and just get one done and read the resources that you have and have your coworkers sign one. Not the people you nominate within the document ideally, but it just needs two witnesses, not a notary. Keep it in a place where it can be found. We talked about that. People say consider putting a copy on the refrigerator, and I've heard this. I don't know how true it is. If you have a stroke or something at the house, emergency personnel are trained to look on your fridge for some of these documents. You may want to double check that information. Please review it every 2 to 3 years. Things change all the time in the medical field. For a while, COVID was a terminal condition. I'm not sure if it still is or not. But you know what I mean, that the advances in medicine may change your wishes, so keep checking it every few years. It's very easy to get a new one, even every other week if you want to. If something changes and you say, okay, oh, I need to go back and change it, please change it. If you provide these documents to anyone, the healthcare power of attorney, the advance directive, make sure you have a list of who has copies. That way, if you do change it every other week, you notify these people so they have the most recent version. You can revoke it. We talked about that. Let's talk about the HIPAA release. We all kind of know what HIPAA is, the Health Insurance Portability and Accountability Act. We know what it does, right? It prohibits healthcare personnel from sharing our medical records. You may know of it because when you go to the doctor's office, they make you sign a simple HIPAA release allowing your spouse or someone else to have access to your records. The HIPAA release that I'm talking about today is a more general document, and it applies to all providers, to whatever you are. That's another document that I use in my estate planning plans. It's just because it's good. Yes, you may have signed one. It's your doctor, your primary care physician. But again, if you're on vacation somewhere, that doctor is not going to have a HIPAA release. And we need people to have access to your medical records. We need people to sign releases and such. How do you get one? The same thing. Find a reputable website. We talked about that. Google Oklahoma HIPAA release, or I think I found it as the authorization to use and share personal information. Google one, use a .gov or a healthcare organization, VA, whomever you need to. But consider getting one. Again, this is just release of information. This is not making decisions. So that's the difference. The healthcare makes your general decisions. The advanced directive makes your end of life decisions. And then the HIPAA just, hey, be able to talk, to call and say, hey, how is mom doing? What did the results say? Well, we cannot talk to you because you're not. Yes, you can, because I have a HIPAA release. The same rules apply here. You need to make sure either the doctors have a copy of it, or that the people you want to have access to your medical records have a copy of it. So that way they can show it to the physicians at that time. Now let's talk about DNR, did not resuscitate. And that's a question that I get asked all the time too. Is any of this a DNR? None of these are DNR. It's its own document. I don't like to talk about it because it's so final. So of course, don't sign a DNR if you don't mean it. Don't even have one around if you think that you're not in that situation. It is intended to be used by a person who is near death. do not resuscitate, right? If you are having a stroke or something, you can instruct healthcare personnel to not try to resuscitate you. How do you get one? The same thing. Google Oklahoma do not resuscitate form, and all this, I'm not just saying it, I did that, before I did the slides, and I do that at the well there in person. We Google some of this stuff together, so you can get a free form for this as well. Google it and then use a reputable organization. Again, you shouldn't have to pay for it. It shouldn't be a weird, website. You should be comfortable you're using the right form. And take it to your healthcare providers and say, is this good enough? Or, hey, I have a question about this. I really want to have this. Um, would you accept this if I'm in this situation? Who should you designate to make medical decisions? This is a big one. It is very simple, though, the answer. The person who would follow your wishes. The person who would follow your wishes may not be the person you are thinking about, okay? It may not be your spouse. That person may not be your kids, young adult kids. It may be your best friend. It may be a friend who works in the medical field. It may be, I don't know who, but that's the person you want to have listed down. During one of the classes at the well, there was this gentleman and he was telling us how his best friend has an advance healthcare directive, listed his daughter, and his daughter is not signing the documents. So I cannot think of anything more devastating in someone's life than to be in that condition. The person and his daughter, because his daughter has to live now with knowing that she's not following dad's wishes. Dad is dying, but the whole family knows that she's not following dad's wishes. It can be devastating. So make sure that the person, again, this goes back to the conversation, should I tell people? Honestly, I don't think personally, I've seen a few names that I know, but please don't ask me, I'm not gonna be that person. I really am not. I can barely make decisions for myself and my daughter, like, do I do this or that? So, please ask someone who's, some people have that personality and they say, oh yeah, you just tell me what you want and I'll sign the documents. And some people, like myself, are gonna say, no, I don't wanna be the one. So, talk to your people and make sure you have the person who will follow your wishes. And these are some of the questions to kind of help you make that decision. Is that person willing, right? They can tell you, no, not me. Are they available? Like if it's someone who has crazy schedule or who travels a lot abroad, or are they the right person? How well do they know you and they know your values? Are they willing to talk to you about sensitive topics? You may have the perfect person in mind that they'll follow your wishes, but they don't like to talk about it. Well, how are they going to know your wishes? Are they able to ask doctors and advocate on your behalf? This is a big one. Someone has to advocate for you if you're unable to do so. And some people are not good advocates. They are good, they will sign, they will talk to you about stuff, but they're not good advocates. So make sure you have that in mind. And can they handle conflict if it arises? That's another big one. People don't like conflict. And some people will say, you tell me what to do and I'll just do it. I don't care who's going to be upset or anything. Some other people are not going to want to go against their siblings' decision or their kids' decisions, or they don't want to be put in that situation. And honestly, it's almost as not fair. We have to have the documents, but it's a really, really tough spot to be in making medical decisions for a loved one. So please think about that really hard before making decisions. So these are the documents that are included in an estate plan. We talked about the power of attorney, the healthcare one. We talked about the advance directive, the HIPAA, the DNR. We did not talk about the financial, the will, and the trust. Those are separate. Consider attending a class or do your research online. Here are some non-medical DIY tips. I know you've had enough of medical information. Consider getting a complete estate plan. We talked about that. But here are some other good things. Verify beneficiary designations. Add and update alternate or contingent beneficiaries. Think about it right now, and we only have one person here, but ma'am, I'm gonna pick on you. When is the last time you checked beneficiary designations?
Well, I just retired, so I had to do a bunch of
Good,
beneficiary.
good.
And I just changed
Very
my
good.
bank accounts.
So you're very good. So that's a good time, retiring, changing bank accounts, starting a new job, leaving a job. Please check your beneficiary designations. It is very important because if you don't have them, your family may have to go to probate, or you may have a former spouse. That would be terrible. You may have a parent because you started that account when you weren't married or something like that. So, and a lot of people don't have alternate or contingent beneficiaries. I meet with them and they say, "Oh yeah, my spouse is listed." Well, what about an alternate? Because if your spouse dies with you or before you and you never change, then you have no beneficiaries. It may have to go through probate. It may get into the wrong hands. Check beneficiaries is free. Even if it takes you 3 hours to do this, it is time well spent. Trust me. Have a list of assets in a safe place, kind of with your other safe documents. Have a list of assets. How are people going to find how many bank accounts do you use and how many different banks? How are they going to find your life insurance? Like if you have, and I know you have good benefits or you have good benefits through OU, but maybe you have bought a life insurance policy through a best friend or through your insurance. How are they going to find that out? Where are they going to get that information? Again, we want to make it as easy as possible for people to help you, whether you are incapacitated or upon your death. Plan for your minor children and pets. We kind of talked a little bit about here before the session. There's a whole session about minor children and designating guardians. Your pets, like if something happens to you, who knows how to take care of your pets? Do they have allergies? Some of them are on medication. Who's their vet? So just kind of leave lists, start giving things away. That's a big one. And I know it may be silly to even be mentioned in this after we talked about all this end of life decision making. Who's going to get your stuff? The way I look at estate planning is, yes, we don't want to go through court, so we want to do as much as we can, but we also want to prevent conflict. And a lot of people, and again, I do probates as well, so I see a lot of this fight over little things. It could be your wedding band, but it could also be a vase that was great grandma's. Who gets that? So have those conversations. And then we talked about the safety deposit box and key. Oh, pin to your phone. That's a big one. Think about who knows the pin to your phone. Think about all the information you have in here. Contact information, Facebook, Amazon, emails, text messages, pictures. If you don't have a safe way for people to access your phone, nobody will get into them. I had someone at the well again share a similar story, can be devastating. Am I saying, hey, go ahead and start giving people your codes and stuff? No, but come up with a safe way. If you have a safe deposit box, it might be a good way to have a list or share it somehow. Make sure that more than just your spouse or your one child knows how to get into that information. What's next? Learn more about estate planning. You can visit our website. You can like us on Facebook. We also have YouTube. I do small educational videos when you have time. You can email me with questions. I know there's a lot of information today. Go back to the slides, use the links that I have provided. Again, come to a class. They are free. They're amazing classes, great opportunity to ask questions. And ask about our rates and everybody else's rates for that matter. Please don't be nervous or intimidated or don't proceed with getting an estate plan because you don't know how much it costs. I think it's a very good question. Ask the rates. How much do you charge for this and that? So then you know. And then I think that's it. I am right on time. 45 minutes. Does anyone have any questions?
We do have one question in the chat,
Okay.
and it goes back towards Krista, please feel free to correct me if I am placing it in the wrong part of the conversation of the presentation, but Krista asked, how can this be connected to someone who has advancing dementia? Is it similar? And I believe that was with the advance directives and the wills, when you were talking about getting that going, and designating.
That is a very, very good question. If someone already has advanced dementia, it's unfortunately too late. Okay. This goes back to my encouragement to do it now, as soon as possible, now that you can, because someone with dementia does not have capacity to do any of the documents we're signing. And yes, you will likely, if that person does not have the documents, a power of attorney, you will have to file for guardianship. You may already be a guardian, but a guardian cannot sign an advance directive that I know of for that person. So unfortunately, only us we are able to sign an advance directive to make those end-of-life decisions. So sometimes people can be kept on life support for a long time just because they don't have an advance directive, and the doctors are not going to, if you don't have those instructions clear, doctors cannot just remove the oxygen or the this and that, I don't know, the a dialysis or whatever they give you. They cannot stop medication unless you have clear instructions written out. So that's a very good question. I'm so sorry to tell you, it is probably too late for a person with dementia to get any of the documents done. Do you have any questions, Mom?
How difficult is it if the person that you designate lives out of state?
Good question. If you guys didn't hear, the question is, how difficult is to have a person who lives out of state to designate in the documents? It depends which of the documents. If it's the advanced directive, the end of life care, you like to believe that the person, if you are in that situation, the person will probably travel. You at least need to make sure that the doctors have contact information for that person, so then they can sign or communicate and do some things. Sometimes people don't have a choice, right? If your kids live in 3 different states, or if you, or the person who will make that decision, remember going back to the people you choose, lives in Washington State, go ahead and still list them with the idea that they will travel. A lot of medical decisions, like emergent medical decisions, the doctors are gonna make them without any documentation, right? They're gonna keep you alive, they're gonna give you all your care. We're talking about a day or two when then your healthcare power of attorney, your advanced directive people can get in touch with the doctors and communicate. So that's okay.